Good morning everyone and Salam Satu Malaysia. Today I'll be talking about professional negligence on the side of thought. Professional negligence is a breach of the duty of care between professional and their clients. The duty of care is common law arrangement where the client expects a level of professionalism and standard commonly held by those in the profession. The usual rules rely on establishing that the duty of care is owed by the defendant to the claimant and that the defendant is in breach of that duty. The standard test of breach is whether the defendant has matched the abilities of a reasonable person. By virtue of the services they offer and supply, professional people hold themselves out as having more than average abilities. These specialized set of rules determine the standards against which to measure the legal quality of the services actually delivered by those who claim to be among the best in the fields of expertise. Even though the general objectives of standard of care cannot come down, it can be raised where the individual defendant has expressly or impliedly represented skills and abilities in excess of the ordinary person. It is an unfortunate fact of life that some professions prove to negligent because even those with the most experience can make a mistake. The consequences to their clients can be disastrous. Thus, professional providing services in a wide range of situations from surveyors and estates agents to doctors, solicitors, accountants, financial service providers, information technology professionals, patent agents, etc. will be judged by the standards of those claiming to have the same set of skills and abilities. The criteria for duty of care in giving advice was stated in more restricting terms in the case of Caparo Industries and Dickman. It is said that what can be deduced from the Hadley-Burn case, therefore, is that the necessary relationship between the maker of a statement or giver of advice and the recipient who acts in reliance may typically be held to exist where, first, the advice is required for a purpose, whether particularly specified or generally described, which is made known either particularly inferentially to the advisor at the time when the advice is given. Second, the advisor knows either actually or inferentially that his advice was communicated to the advisee either specifically or as a member of an ascertainable class in order that it should be used by the advisee for that purpose. Third, it is known either actually or inferentially that the advice so communicated is likely to be acted on by the advisee that purpose without independent inquiry, and lastly, it is so acted by the advisee to his detriment. As to solicitors, the case of Ross and Qantas holds that lawyers can owe a duty of care both to their clients and to the third parties who suffer loss or damages. In that case, a solicitor failed to prevent the beneficiary from attesting the will. They were admitted negligence but denied that they were liable to the claimant, contending first that the solicitor was liable only to his client and then only in contract and not in tort, and could not therefore be liable in tort to a third party. Second, that for a reason of policy, a solicitor ought not to be liable in negligence to anyone except his client. And lastly, that in any event, the plaintiff have no cause of action in negligence because the damage was suffered was purely financial.
For this part of the lecture, I will be sharing some examples with all of you with regards to our topic of discussion, professional negligence on the part of a legal practitioner. Before I get into the examples, it is important to keep in mind that we may encounter unfortunate incidents in which professionals act negligently in their services they provide. Specialist advice is essential for those who are unlucky enough to find themselves in such a situation. Most clients may not understand when their solicitor is negligent in their duty towards them. Therefore, there are some examples of professional negligence of a legal practitioner, and the first one would be missed deadlines when serving or filing documents to the court, client or opponent, which is detrimental to a client's case. Slide 2. Another instance where professional negligence can be seen would be when an advocate or solicitor is absent in court on the trial date and fails to inform the client on the date of the trial. Slide 3. The next situation in which professional negligence can be seen would be when a solicitor or advocate is found to be negligent when he or she files an action in the wrong court. For example, in the Malaysian context where the action was filed in the Sessions Court, whereas it should have been before the High Court. Slide 4. Moving on, another case of professional negligence by a solicitor or advocate would be while preparing the pleading counsel knew that his client had done some act which would preclude that client from recovering, but counsel all the same neglected to address this point to the knowledge of the client or to point this out to the client. Slide number 5. The fifth example is when the counsel relied and proceeded under a wrong statute or section of a statute or failed to even refer to the correct statute. Slide 6. The final situation in which a legal practitioner can be sued for professional negligence would be when he or she is of the knowledge that success is improbable, yet a counsel proceeds to advise his or her client to enter into litigation.
Slide 1. We now move forward to recent reported cases in Malaysia on professional negligence. The first case in hand is the case of Sri Alam Sdn Bhd against the Tuan Razwan Ibrahim in the year 2010. This case started off when the plaintiff, a housing developer, was sued for non-payment of legal fees by his former solicitors. It was argued that the summary judgment and affidavit in reply was filed out of time because solicitors were unaware of the new ruling. They informed the client and explained the consequences and elected to proceed without the affidavit purely on the point of law. However, it was held that because the defendant had provided the plaintiff with a written opinion and also explained all the alternative causes to action, they are presumed to be not at fault as the duty of care on their part was given as solicitors. So they could not be faulted in any way. The court ruled that the plaintiff had failed to prove any breach of duty either in contract or law. A more recent case in point would be the case of Kuala Excel Sdn Bhd against Chua Ling Hong in 2018. The issue put forward was whether the appellant had succeeded in proving its allegations of misrepresentation and professional negligence against the respondent in his capacity as the solicitor when advising the appellant in regards to the consent judgment entered. It has been decided in several cases that a solicitor has a duty to warn his client of the risk that he is facing, otherwise the solicitor would be liable for negligence. In this case, the respondent did not advise the appellant on the legal implications of the consent judgment entered. He did not carry out the required searches and inquiry as well as no explanation nor advice to the appellant on the legal implications of filing a POD. Therefore, the Court of Appeal held that the respondent had breached his duty of care to the appellant and such breach has caused the appellant loss and damage which gives rise to a breach of duty of care. The two cases put forth shows the importance to maintain the required standard of care when discharging duties as a solicitor towards the client. Slide 2. Moving on, a few cases are put in place to show facts that do not constitute as negligence. In Hart against Joan, an advocate is not liable for errors of judgment committed without negligence, whether the error pertains to law or discretion. Next, in Dunlop against Woolhara Municipal Council, where the error of judgment involves points of new occurrence or doubtful construction does not constitute negligence. Lewis against Callard shows that where the solicitor has merely acted upon client's instructions in the reasonable belief that they were correct, it will not be sufficient to show breach in duty of care. And in the case of Clark Boyce against Muat, where a solicitor has clearly explained the position to his client but is nevertheless instructed to proceed by the client will not make him negligent.
In the issue of professional negligence, I'm here to discuss regarding the position of UK and Malaysia. Firstly, in the position of UK, it is divided into two parts since the beginning based on the case of Rondo and Worsley. It is stated that a barrister shall enjoy immunity from being sued on negligence, as every counsel has the duty to raise an issue for the client, and the counsel has an overriding duty to the court, profession and public, even if it may conflict with the client's interest. However, after 20 years, the House of Lords provided a new decisions in this case of Arthur J.S. Hall and Simmons. Simmons claimed that his solicitor provided advice for his divorce negligently, which caused a lengthy and expensive litigation. Also, in Barrett and Ansell, He claims that his solicitor advised him negligently to settle his divorce term on disadvantageous term regarding the wife claiming for a share in the matrimonial home. Lastly, in Harris and Scofield, Roberts and Hill, Harris claimed that her solicitor negligently advised her to settle her claim with her husband by putting her in a disadvantageous position. In all these cases, the solicitors claim that they enjoy the immunity of being sued for negligence. However, the court held that immunity from suit for negligence is removed as standard of care have to be applied against an advocate, alike as any other skilled professional that is required to make decisions. Plaintiffs have to provide evidence that negligence existed, and the advocate must not mislead the court and ensure that all facts are presented. In Malaysia, a client can bring an action against an advocate and solicitor under contract or tort. In Section 114 Legal Professional Act 1976, advocate and solicitor may enter into an agreement for remuneration from client, and it shall be in writing and signed by the person bound by it. And Section 117 Sub 4 of Legal Professional Act 1976 stated that any agreement with a client which states that the advocate and solicitor shall not be liable for negligence, it shall be wholly void. There are three elements to be fulfilled which can be seen in the case of Arab Malaysian Finance Berhad and Stephen Forward, which states that in order to prove that tort of negligence, plaintiff must prove that defendant owed the duty of care towards the plaintiff, defendant breached their duty, and plaintiff suffered damages. In Nyo Suo and Retina Sami, the solicitor failed to conduct a land search and he is liable to compensate in tort for breach of duty of care. While in Syarikat Xiao Tech Hall, Realty and Development Sendirian Berhad and Malik and Joseph, defendant represent plaintiff for a civil suit. However, later on the appeal was struck out. Defendant failed to appear in court, and the court held that there's indeed professional negligence and failure of appeal for hearing was being disrespectful towards the court. Lastly, in Lim Suwa and another and Wong Sin Chong, the advocate and solicitor absent in court and failed to inform the client on the trial is liable for professional negligence.
So now we'll be looking into the position of professional negligence in other countries. For instance, in India, we have this case of Pandurang Datrata Kandika, in which the Supreme Court held that there's a world of difference between the giving of improper legal advice and the giving of wrong legal advice. So basically, as a matter of fact, no advocate can be found fault for a wrong legal advice. Besides that, the Supreme Court also pointed out that an advocate and solicitor is expected to follow the norms of professional ethics and try to protect the best interests of his client. It also has been stated that for an advocate to act towards his client otherwise than with utmost good faith is unprofessional, and therefore what the petitioners have done to the client is only in the due discharge of their professional duties. So what are the elements that cause professional negligence? The first one is that either the advocate and solicitor was not possessed of the requisite skill, and the second one is that he did not exercise with reasonable competence. So what are the punishments in India in terms of professional negligence? This can be seen in Section 35(1) of the Advocates Act 1961, which states that when a receipt of a complaint or otherwise a state bar counsel, has reason to believe that any advocate on his role has been guilty of professional or other misconduct, it should refer the case for disposal to a disciplinary committee. And now we'll be looking into the professional negligence in Australia's point of view, where we have this case of Alts, Turner and DCL. So basically this case was held in a administrative tribunal, and this case followed the principle in Haywood and Wallace. So what happened in this case is that the plaintiff's suitcase was lost by the Qantas airline while they were holidaying in Australia. So the solicitor had lodged a claim with Qantas Airline, which relies on the Civil Aviation Carriers Liability Act 1959 to limit its liability to $1,600 per passenger. So basically, the Turner has rejected the offer of $3,200, but without having received advice about the act, saying that the solicitor could have squeezed more out of Qantas by the threat of adverse publicity in the context of media attention than being attracted to baggage theft. However, the solicitor refused to pursue Qantas Airline further unless the opinion of a barrister experienced in aviation law could be procured. The Turners refused to continue such expenses. So in this case, senior member, however, found that advice of the counsel was unnecessary on such a simple point, that a competent solicitor will simply have looked up the act and advise that the $3,200 was the most the tenants were going to get. So instead of advising, the solicitor carefully avoided it and let the matter drift aimlessly. So in conclusion, senior member ordered the payment of the balance back to the tenants.
To conclude, legal practitioners in Malaysia have never been immune from suits against professional negligence. Since the relationship between the client and solicitor is entirely fiduciary, the solicitor may be liable to compensate for any losses incurred by the client due to the negligence of the solicitor itself.